Administrative agencies have the power to promulgate legislative rules, which have the force of law, but not every agency rule is legislative. Some merely interpret or guide the enforcement of legislative rules. In American Mining Congress versus Mine Safety and Health Administration, the court clarified the test for determining whether a rule is legislative or interpretive. The Federal Mine Safety and Health Act regulates mines and authorizes the Secretary of Labor to enforce the law and promulgate relevant regulations. One section of the Act requires mine operators to create, maintain, and report records as required by the Secretary. The Mine Safety and Health Administration, or MSHA, acting on the Secretary's behalf, promulgated regulations, known as Part 50 regulations, through notice and comment rulemaking. Under Part 50 regulations, whenever a worker was diagnosed with an occupational illness, the mine operator had to report the diagnosis to the MSHA within 10 days. The MSHA occasionally issued Program Policy Letters, or PPLs, which conveyed the agency's policies, guidelines, and interpretations of its regulations. PPLs were promulgated without notice and comment and weren't published in the Code of Federal Regulations, or CFR, but were distributed to mine operators, trade unions, and other interested parties. The MSHA issued a PPL stating that any chest X-ray of a miner that scored higher than a certain threshold would be considered a diagnosis of silicosis for the purposes of Part 50 reporting requirements. The American Mining Congress challenged the PPL in the District of Columbia Circuit Court of Appeals, contending that it was a legislative rule requiring notice and comment rulemaking.